Welcome to Second to None Media. I'm your host, DJB. You're watching the latest courtroom coverage in the state of Texas case involving the death of Dallas rapper MO3. In today's hearing, the court hears a back-and-forth dispute between prosecutors and the defense team representing Kewon White. The discussion centers around discovery obligations, including information related to potential witnesses, law enforcement testimony, agreements, co-defendants, and evidence that could play a role at trial. Both sides present their arguments before the court as the judge considers the issues raised. This coverage is presented for news reporting, educational purposes, and public interest. All defendants are presumed innocent unless proven guilty in a court of law. Let's go inside the courtroom.
All right. So both sides ready to proceed?
State's ready, Your Honor.
Defense is ready, Your Honor.
Let's get on the record. These are cause numbers F2500179, F2077085, F21777, F2039200, and F2039490. All filed the State of Texas versus Kewon White. Is that your name, sir?
Yeah, well.
All right, will the attorney announce their presence?
Bree West on behalf of Mr. White.
Myra McIntosh on behalf of Mr. White.
Yella on behalf of the state. Tom Young, State of Texas.
Thank you. And Mr. White's cases are set on the court's docket today for a pretrial hearing. Have both sides filed their pretrial motions?
Yes, Your Honor, and the state does have one additional agreed order that I had sent to defense. I have not filed it because we haven't agreed on it yet, but I did send an agreed order to all defense counsel. This will encompass Mr. Conway and Mr. Brown's cases as well. That's the only thing we have left outstanding as it relates to Mr. White. Our motions were previously ruled on in either January or February of this year, I believe.
And in response to that, Your Honor, it's my understanding, and I think the state can potentially correct me, it's my understanding that there may be some amended or updated 404B notice that will be provided to us that really directly sort of addresses our motion for 404B and extraneous offenses and motions in limine.
And I don't have any of your motions in front of me at this time. I know I ruled on the state's motions the last time we had a pretrial.
Correct.
And the defense hadn't yet filed their motions.
I'm happy to print those and provide those for the court, Your Honor.
Okay, where are they?
They are e-filed. I can email them to you if that would be easier for the court, but they are on...
You emailed them yesterday? You e-filed them yesterday?
Yes, I didn't email them to you directly, Your Honor.
Okay. Has the state had an opportunity to review those motions?
No, Your Honor. They came in, I believe, after hours, and I was not able to review them this morning. Myself and Mr. Yella have begun reviewing the motions filed by defense, and I believe we could probably address those today.
Okay.
We would probably need an hour break or so just to review what we can and cannot agree to as far as our motions.
Okay. And this agreed order that you speak about, what is it?
Yes, Your
What does it
Honor.
entail?
The agreed order that we've provided to all the attorneys on our cases, we will provide a motion or an order as far as us turning over criminal histories as it relates to individuals. A lot of times that is asked by defense in their motions anyways. So sometimes, or most of the time, we will file an order, agreed order, to turn over the criminal histories in our possession. Otherwise, we can't. So that is encompassed in this agreed order. Also includes text gang database information.
Why would I need to sign an agreed order for something that the state is already duty-bound to provide to
The law actually, as it relates for our CJIS compliance and our compliance with the text gang database, and as well as our compliance with NCIC, TCIC, and our access to that, it has to be ordered by the court that we turn those things over. We cannot just willfully turn over those things. Those are a lot like, for example, one of the other things in here is mental health records, as it relates to individuals, like those are things that a court would have to order us to turn over, just like for
Yes, and I usually do. I order the state to turn those over pursuant to discovery.
Sure.
Michael Morton. I don't need a separate order to do that. And I'm not asking y'all to turn over the TCIC, NCIC records, just information from those databases with any criminal history that you know of,
Sure.
that you've researched.
And just to make things, in my experience in handling these, especially with the amount of discovery we have, typically what I will do, Your Honor, I will run every witness that we intend on calling, civilian witness that we intend on calling, we'll typically run them the Friday before trial. That way we have a very clean, fresh NCIC, TCIC, as well as any texting database information. And then I will turn that over via text share to defense. Of course, 3914, restricts their ability to hand that out, but that ensures that.
But you want to hand it out.
I would, yes, via text share. And speaking with our lieutenant who handles our CJIS compliance, and as well as speaking with DPS and who handles their texting database, everybody's on board that this is an okay way for us to do it. And then that way defense counsel isn't relying on me transcribing or reducing the NCICTC into writing into what I believe it says or shows. That way they have all that information exactly as it is represented on the NCIC-TCIC, as it is represented on the text game pronounced if there are any. And that way I'm out of creating a record or a document that they are then relying upon. Because I don't want anybody to have to rely upon any document that I am creating or reducing something into a form. So this, in my experience, has been the easiest way to handle things, and has been my practice at least since before the pandemic.
That you would prefer, or would you prefer for the state to review those records and inform you of whatever criminal history their law enforcement and civilian witnesses have?
So, Your Honor, I think it has a lot to do with like how voluminous it might be.
Right.
And so that and the only other issue I would have is if it is voluminous and we receive it the Friday before trial, then how are we to investigate or address anything that may come up for impeachment purposes that may be contained in that NCIC?
And just to clarify, two parts. Number one, if this agreed order, we could agree to it, I'm happy just making everything that I have now that is in our possession as of today, making it discoverable today. As far as the civilian witnesses that we have histories for and criminal records for, that way they have a month to investigate it. The only reason I do it on the Friday before is just to ensure if somebody picked up the case in the 31 days between now and the start of trial. That is just to, again, give the defense a fair trial. And I would also like to clarify, we do not run criminal histories on law enforcement officers. Our office has a procedure where we...
Your Brady department?
Yes, we run,
Okay.
I will have all of my officers run through our Brady division that runs all the officers, and I will turn over any information that comes back from them. We do not run NCIC, TCIC on officers.
Well, regardless of that, regardless of what your Brady department does, I'm ordering the state to turn over any criminal history that any of your law enforcement witnesses have. It's your duty to discover that, whichever way you need to, and turn that over to the defense, regardless of your Brady department.
Well, in Your Honor, I would direct the court to, and I can get the citation for the court. I believe Ms. West was actually the prosecutor in the court for a case. It's entitled In Ray Watkins. I believe Ms. West was actually ordered to do the same thing, and the Court of Criminal Appeals came back and said that that would cause us to create records that are not in our possession. And I would just direct the court to that.
No, I think there's a difference here. I'm not asking you to create records that are not in your possession. I'm asking you that if there's any criminal history known to you,
Sure.
which you are duty-bound to discover,
Absolutely.
that the defense can use to impeach your witnesses, whether they're law enforcement or civilian witnesses, you are to discover those and turn them over to the defense. I'm not asking you to create a document or create discovery. I'm asking you to hand over what exists. Okay?
I, of course, will comply with all my obligations under 30.
As you should, yes.
And Brady. I'm not trying to argue that. I just want to make sure that we're clear.
Yes.
If there's anything ever known to us, we would, of course, turn it over. However...
And anything that you should discover.
Sure. I completely agree with
Proactively.
just so we're clear, is the court ordering the state to run every single witness through a database?
No, what I'm asking you to do is if there's any law enforcement witness that you have that you're going to call and they have a criminal history.
Correct.
Or any material information that can be used to impeach them or that's beneficial for the defense, you are to turn that over to the defense.
Correct.
I think my ruling's clear.
Yeah. Thank you, Your Honor.
All right? Okay, what next?
And that...
Your personal information is valuable, and every time you connect online, you're trusting networks to keep your data safe. Whether you're using public Wi-Fi, traveling, working remotely, or just browsing from home, protecting your online privacy matters. NordVPN helps encrypt your internet connection and adds an extra layer of security while you're online. Right now, NordVPN is offering a summer deal with up to 76% off, plus 4 months free, bringing plans down to as low as $3.37 a month with a 30-day money-back guarantee. Protect your digital life today. Check out the offer by scanning the QR code on the screen.
This concludes part 1 of today's courtroom coverage. The state of Texas and the Kewon White defense team presented opposing arguments regarding discovery and what information should be disclosed before trial. In the next video, we continue with another major issue from the hearing, the debate over which defendant should go to trial first and the concerns raised by both sides. If you appreciate our courtroom coverage, please like this video, subscribe to Second to None Media, turn on notifications, and follow us across all platforms for more legal updates and in-depth reporting.